Honorable Neil May, good morning.
Morning, Chair. Morning.
Morning, Chair.
Good morning, colleagues. So the sound check works. So honorable members, today we continue with the processing of the RAF report. We're not too far from the end, but we've got possibly 2 to 3 more sessions on this round, and then we are going to bring it all together with the changes identified, so that we can just process it all the way through. So we're not too far from the end. So today we are looking at the issue of Sunshine Hospital. It is one of the issues that came up as a result of the invitation for the public and affected parties to send through their issues, one of the initial submissions. So I also want to thank the team from Secretariat as well as the legal department for assisting us with pulling this together. It's a lot of work in and among the other things that they have to do to support the company, and for Ms. Ibrahim to support the speaker and other committees and so on. So thank you for the time that you make, all of you, to make this possible. So the members have the report, but we will do as we normally do, which is to give Ms. Ibrahim the chance to go through the report so that she can give color to some of what has been put in this section. And then we will take the feedback of the members, note all of those, and then, like I said, when we have a sort of a version for approval, we will then show all the inputs. Thank you so much. Over to you, Ms. Ibrahim.
Thank you, Chairperson, and good morning to yourself and all the honourable members and staff on the platform. Chairperson, just a reminder to members that the sessions that we're doing where we report back on individual sections, they don't include our recommendations. So our discussions through these processes will inform the recommendations that will come at the end of the report. By way of background, when we did the public participation process, there were a number of submissions that referred to or related to Sunshine Hospital. The first being the fact that the co-owner and managing director of Sunshine Hospital had, via his attorneys, put in a submission claiming that as of July 2025, that the RAF was indebted to Sunshine Hospital in an amount exceeding 300 million. And the submission provided quite a bit of information on judgments in which the RAF was ordered to pay these outstanding amounts with interest and costs. And then also members will know that we had several submissions from former employees alleging that they were unfairly dismissed in respect of conduct relating to Sunshine Hospitals. So what we knew from the outset was that Newnet was a private hospital in Gauteng, which primarily serviced motor vehicle accident victims. And it was clear that the Sunshine Hospital matter involved hundreds of millions of rand. So we had a number of submissions from individual medical practitioners and so on, claiming that monies were owed to them. But this one was a little bit different because of just the sheer amount involved. Also, the fact that there was this accumulation of interest and legal costs in respect of all of the ongoing litigation. So the committee was particularly concerned as to the reason for the alleged debt and whether that non-payment was legally defensible. Because obviously we know that ongoing litigation is costly and can result in fruitless and wasteful expenditure. And then also one couldn't ignore the fact that you had a number of former employees saying that their dismissals were linked to Sunshine Hospital. And the labour matters are not dealt with in this particular section of the report. We do deal with it later. And also, just as a reminder to the committee, we don't look at the merits of individual labour matters or reinvestigate or relitigate those matters. The extent at which we will consider it is to see whether it has a bearing on the financial issues. But we do refer to it to some degree in the section of the report. In terms of evidence, the committee received an affidavit, and we also heard the oral testimony from Mr. Ken Ford, who's a co-owner of Newnet Properties, and he assumed the management responsibilities when UNet acquired that hospital in 2022. And according to the evidence before the committee, he was approached by RAF employees in 2003. These employees were from the RAF outreach program, as he understood it, and they requested that Sunshine Hospital admit and treat patients who were initially admitted at state institutions, but due to capacity and resource constraints, couldn't provide further services. And in his understanding, Sunshine was approached because it was willing to accommodate RAF patients who were not on medical aid or did not have the economic means to afford private medical care. So members would know typically when you go to a hospital, the first thing that you'd be asked is whether you're on a private hospital, at least, is whether you're on medical aid, or if you're able then, in the absence of that medical aid, to pay a deposit prior to you being admitted. And Sunshine Hospital was one of those hospitals that was willing to admit patients in the absence of those two things. He indicated that notwithstanding this arrangement and request that was made to him, he was not a service provider in the sense that his services were not procured through a bid process. Rather, Sunshine acted as a supplier under Section 17.5 of the RAF Act. And in terms of that section, medical service providers can submit direct claims to the RAF by completing a prescribed RAF2 supplier claim form. In that case, obviously, the RAF then wouldn't pay the injured person those costs. So it's a case of either the injured person makes that claim if they've paid it themselves, or otherwise the service provider can claim directly. The suppliers are then paid or meant to be paid in accordance with the prescribed tariff. The Act refers to that tariff. And Mr. Ford explained that there was no need, therefore, for any supplier or service level agreement because the arrangement was a statutory arrangement. And his explanation accords with the evidence we heard from Ms. Christina Mtetwa, the former Regionations manager, who also said that these services rendered by Sunshine were always in terms of the RAF2 form. And of course, it wouldn't have been the case that only Sunshine made claims via RAF2. There would have been other hospitals and other medical practitioners doing exactly the same thing. So firstly, it's important that members understand from a legal perspective that if you're a victim of an MVA, you're not compelled to seek treatment at a state hospital in order for you to make a claim against the RAF. You can do so at a private facility, but of course, you then carry the risk that the RAF is not going to compensate you in full, and you're going to have to then pay the shortfall. There has been quite a lot of criticism and challenge in respect of the tariffs. The minister has been criticized for imposing tariffs that are below cost and that are not market related. And the argument, of course, is that this impacts MVA victims adversely because you have an overburdened public health system where I may not be able to get the level of care or care as quickly as I need it. But at the same time, if I do go to a private hospital, there is, of course, then this very huge risk that that bill is not going to then be paid in full. So Sunshine really was bridging that gap to some extent, because at least it allowed people then to have access to private healthcare. And according to Mr. Ford, they were billing in accordance with the tariff. So in November 2007, the relationship gets formalized and a cooperation agreement is signed between RAF and Sunshine. Mr. Ford indicated at this point there was already a history of late payments, but the fact is that payments were eventually made. He provided a copy of that agreement to the committee, and we also received a copy from the RAF. We made sure that they were identical, and the salient aspects of that agreement was that this is a pilot project, and the aim is to ensure that claims are settled effectively and efficiently. And on the one hand, the fund will assign its staff to assist the hospital, and the hospital, on the other hand, will provide the fund staff with suitable office space and related infrastructure. It then said that the fund is not obliged to make exclusive use of the hospital to render the services. As I said, a person would be able to go to any hospital they wish to go to. And this agreement became effective on 1 November 2007. And there was no termination date. It would persist in perpetuity unless it was cancelled by either of the parties on notice. The fund had undertaken to assist MVA victims to lodge claims directly with the funds, and that speaks to the direct claim strategy that we had heard about during the hearings, and they would then administer those claims in terms of the RAF Act. And Sunshine, on the other hand, was providing the fund with suitable office space and really assistance to run that office. So access to telephone lines, their network points, and even the use of a vehicle at no cost. Sunshine had then also undertaken that they would give the fund access or reasonable access to all of their records and accounts to enable the fund to render these services. And Sunshine would also allow access to third parties with their consent. So, in other words, that RAF employees could come in and speak to the patients themselves as long as the patients consented. And the fund would have case managers that would come and do this. And these were meant to be people that have sound clinical knowledge and training. And they would then also have access to doctors to discuss prognosis, treatment, and rehabilitation. So, really, the aim was to see whether a sort of a joint approach where the RAF is involved really on a day to day basis rather than at the back end after services have been rendered. So, in other words, a consultative process while the person was undergoing treatment. So, Mr. Ford testified that notwithstanding the original arrangement, that Sunshine would deal primarily with MA victims who required further or ongoing treatment, they eventually started receiving patients for immediate treatment. So, in other words, an accident has occurred and an ambulance service then brings that patient directly to Sunshine Hospital. So, typically, it would be state hospitals that would be the default delivery points in the case of an accident. But state hospitals are not always able to accommodate or treat these victims immediately. Or sometimes they stabilize and assess them and then transfer them. So, according to Mr. Ford, this transfer would be done from a state hospital to Sunshine via a form that would be completed by the hospital superintendent or otherwise their designated official. And he gave the committee an example of what this transfer document would look like. And according to him, if you recall in his testimony, he said that in every single file, there would be a transfer document. That would be the very first document that you would find in the file. And he gave us an example. He said he had many examples, but one of the examples that was given was that there was a patient who had already spent 61 days in a state hospital without having received any treatment, and then was finally transferred to Sunshine, where the patient was treated within 7 days, within 9 days rather, and then discharged. And what he was trying to illustrate was that there's a benefit of transferring a patient to a facility that has the resources and the capacity to treat that patient. Otherwise, you're merely accumulating costs in the public health system when you can't treat the person immediately, but you still have to have that patient admitted. Or even if you're making the patient come back and forth, you're clogging the system. And this evidence was also echoed by Ms. Mtetwa, who noted that if a patient isn't treated timeously, there's then a risk of further injury. And of course, that will result in further compensation costs. So you really want to treat people as soon as possible and as fully as possible. And if that's not done, obviously your costs are going to increase. He had indicated that between 2013 and around May 2025, they had received transfers of patients from approximately 130 state hospitals due to these capacity or resource constraints. And those sort of restraints included things like not having sufficient numbers of specialists, where equipment may have been faulty, or there's unavailability of medication or consumables that you may need to perform surgery and so on. What we have done is requested a list of these hospitals so that we can then refer it to the Portfolio Committee on Health to take a closer look at this and to conduct oversight, because this is obviously a matter of concern. Because had public hospitals been functioning effectively, then this sort of scenario then wouldn't have transpired at all. There wouldn't have been a need then for these patients to be transferred. So in or around the time that this agreement was signed in 2007, Sunshine Hospital and a RAF agreed to a system for the processing of the claims, whereby they would do a consolidated claim in respect of a patient as opposed to several individual claims. So members will recall there was a question asked to Mr. Ford as to what the relationship was between the hospital and the medical practitioners. And he said that it works exactly the way it does in any other private hospitals. These doctors rent space, they rent theatre time, and so on. And historically, those sorts of claims would have then each been dealt with as individual separate claims. So each doctor treating a patient and each medical practitioner would send their own claim. The physio would send something, the knee specialist that treated that person would send something, the hospital would send something, and so on. And the RAF would then have to consolidate all of this and make sure that everything tallies and makes sense. And what was proposed was to do this sort of consolidated or global concept where instead of having these separate claims, you have one account that includes everybody's claim. And the basis of that was that it was meant to make things easier for the RAF. Because they would then be able to check that everything makes sense, that everything tallies, that a doctor that's treated a person for a knee injury, it is because that person genuinely has a knee injury. Because then you might see, for example, that there was an anaesthetist that says, I'm billing for an op that's completely unrelated to the knee. And of course, that would then set off alarm bells and you'd be able to check immediately that, this doesn't make sense because this information is not telling. Whereas in the old system of doing it as individual claims, one may not have that full information before them because claims are coming in at different times. So, according to him, this system worked uninterrupted for 17 years until the RAF, quite recently in litigation, raises it as a defense for non payment. And I will take the committee through that case a little bit later. About 11 years after the cooperation agreement was signed, it was then unilaterally terminated by the RAF. Mr. Ford understood it to be a temporary arrangement on the basis that there's going to be a new cooperation agreement that would be signed with private hospitals, that it would be renegotiated. So as far as he was concerned, it wasn't a case that the relationship was ceasing to exist. And that seems to be supported from correspondence in the committee's possession from Ms. Linda Jabavu, who was acting CEO at the time, where she notes that the RAF looks forward to future engagements, which will be formalized in due course. So there was no reason to believe at that point that the termination was a termination that sought to permanently cut that relationship. And in any event, notwithstanding, even if it was a termination in the true sense, as I've indicated, Sunshine would still be able to treat these patients because patients are at a liberty to go to whatever hospital they wish to go to. According to Mr. Ford, even though this termination had been effected, both parties still adhered to the terms of the cooperation agreement. So it really was business as usual. The consolidated accounts continued. They continued to utilize the office space and have a presence at the hospital. Members may recall he even read out to us an email that they had written asking about placing additional signage. So as far as things were running from a practical perspective, it really was continuing as it had for the 11 years to date. The issue of late payments, however, still persisted, but they were eventually getting paid. Ms. Mtetwa also indicated that patients were being treated at Sunshine, notwithstanding the cancellation, and she too stressed that in any event, Sunshine had the right to submit those claims in terms of Section 17.5. And of course, members will recall that according to Ms. Mtetwa, they weren't really ever formally told about the cancellation of this cooperation agreement. And we will deal with that when we get to the labor parts later on. Then there was a moratorium then on payments and investigations into irregularities. So after the cancellation of the cooperation agreement, a new agreement isn't actually then entered into. But because it was business as usual from 2018 onwards, things just continued as they had in the past until in April 2020, Mr. Ford testifies that payment is then stopped. So that's a blanket stopping of payment, and there is this moratorium on all payments to Sunshine Hospital. He's not aware at this point that there is a moratorium or why payments have stopped, because in his mind, these payments are now on the RNYP, which are requests not yet paid. Members will recall those are invoices that have already been vetted. They've already gone through an internal process at the RAF, and they're now in that queue for payment. So according to him, he's got all these payments that are reflecting as due on the RNYP, but payments are not coming in. And he makes some effort to try and understand what the reason is. But it's only really in August 2020, after several attempts at obtaining the information, that he's advised by Ms. Chabavu, who's then Chief Operating Officer, that the RAF's Forensics Investigation Department, and that's the internal department, was conducting an investigation into invoices submitted by Sunshine, and that no payment will be made by the RAF linked to claims submitted on behalf of Sunshine until the investigations have been finalized. And it also then said that in light of this investigation, this precautionary measure in withholding payment is necessary and prudent to ensure that the RAF limits any potential risk exposure that may emanate from making payment on claims without verification. And Mr. Ford says at this point, he's not aware of any irregularities, and all his attempts at obtaining further information and trying to get to the bottom of this are unsuccessful. He is visited by investigators. There is an investigation that has started, and he says he's provided the investigators with all the information that they required, and the committee has no evidence to suggest that at any point Sunshine didn't cooperate with that investigation or any other investigation. The internal investigation is concluded in September 2021. So really more than a year after the moratorium is implemented. And Mr. Ford says that they weren't given a copy of that report, notwithstanding that in that letter from Ms. Chababu, they had indicated that they would be updated and they would be provided with a copy of the letter. However, it seems that a copy of it was inadvertently sent to his attorneys, and this is how they then came to know what the content of that report was. We did ask for a copy of that report from the RAF as well, because obviously the copy we had was the copy that was inadvertently included in litigation processes between RAF and Sunshine, and we wanted to make sure it was the exact same report, that perhaps it was an issue that the copy that Mr. Ford had wasn't a complete copy, but it seems that the two are identical. And that report concludes that the investigation could not establish any evidence of collusion between RAF employees and Sunshine Hospitals in terms of the review documentation and information received through interviews. And members will now recall that you have an issue where staff are being dismissed on the basis of this collusion, but this investigation finds that there is no evidence that could establish that. And then the analysis of the spreadsheet at this stage also do not indicate any irregularities. And in respect of over-servicing and duplication of payments, they say that invoices submitted by the doctors at Sunshine indicate that the services were indeed rendered to claimants and patients. And there's no evidence of over-servicing or duplication of payments that could be established thus far. They then conclude that in terms of the moratorium, that it should be reconsidered, as all evidence thus far point to the fact that the services were rendered and payment for such services are due. The committee then requested the RAF to provide any further investigative reports that may contradict the findings of the internal investigation, and they were unable to produce any other definitive report. The committee was, however, provided with the following. The first is a 2022 report prepared again by the internal FID in relation to allegations against Ms. Mtetwa. And that report dealt with the allegations that she was transferring patients to Sunshine Hospital. And in essence, it's that she facilitated these transfer of patients, notwithstanding the termination of that cooperation agreement. So, whilst the report recommended disciplinary action against her and several other RAF officials, it did not contain any finding or allegations of wrongdoing against Sunshine Hospital. But, that of course also begs the question that if there is collusion, then the collusion has to be on both parts. You can't have collusion with only one party. The same with any other corrupt relationship. It requires two or more parties. We were then provided with a 6-page report dated 11 September 2023. And so this comes almost a year and a half after the moratorium is already in place. And it's prepared by a private company called Universal Care, which is an accredited managed care company. And that document, it's quite loosely drafted. It's called RAF Case Reviews Batch 1. So it seems to suggest that there would have been other batches following thereafter. And it says that the report was commissioned on behalf of the RAF by Malachi and co-attorneys for purposes of conducting an audit of 29 case files relating to claims submitted between June 2018 to November 2021. And what they do is they do an analysis of all of these bills and these accounts, and they look at things where perhaps the RAF shouldn't have paid. So examples being where there wasn't an ICD-10 code. So members will know that if you're on medical aid and you submit a claim to your medical aid, unless you have the correct ICD-10 code, your medical aid will not reimburse you. So what that report is saying, well, in the absence of certain ICD-10 codes for some of the treatment, RAF shouldn't have paid. In some cases, there may have been clinically inappropriate treatment. And they estimate that had the RAF considered those invoices more closely, they could have saved an estimated 29.28% of the bill. So in other words, their finding is that the bills were inflated by that percentage. And they recommend that clinical and billing audits continue, as the current review raises suspicion of billing practices that are wasteful, abusive, or non-compliant with legislative requirements for billing, as well as suspicion of care that is clinically inappropriate and representative of over-servicing. That report is then followed up by an April 2024 report, which is also by Universal Care and relates to those same 29 files. And again, it's Malachi and co-attorneys that instruct them. And really, it just goes into a little bit more detail than the previous report. And what we've uncovered is that the purpose of that second report was following litigation that had occurred where the court had criticized deficiencies in the earlier September 2023 report. But what's important in this report is that the company notes that their review is limited, and they put in a disclaimer that says no counter arguments were provided and taken into account, and there weren't any opportunities to request additional information or clarification relating to certain claims. They go on further to say certain cases had limited information or outstanding information, which made it difficult to analyze the case, and the report is therefore based on information that was available to us. So this isn't a forensic investigation that occurs to the extent where the other party is given an opportunity to respond to allegations, to provide additional information. They're dealing by the limited information that they've been provided by the RAF itself. So that the report found that there are cases where the interventions deviated from normal clinical practice usually observed in similar circumstances. And the significance of the findings indicate that the RAF might be exposed to claims which are inflated and where the level of care is not appropriate. It further found that there were various discrepancies between the claims of different providers who rendered services to the same patient and that the clinical notes are incomplete. So they conclude that there is an opportunity to prevent fraud, waste, and abuse if the RAF has the capacity to properly review each claim that is submitted before payment is made. And they note further that the cases are complex and require experienced personnel to review the files and request outstanding information or motivations where indicated. So, in other words, what they're saying is before you load your invoices on the RNYP, when you're going through your invoices, you need to make sure, obviously, that everything is in order. That it's at that stage that queries should then be sent to Sunshine Hospital or any other medical practitioner to verify information or to get clarity on why something is billed the way it is. Members may be aware that even in government, when we procure services, when an invoice comes in, we're duty bound to check that invoice and ensure that it's correct. So, for example, where we have counsel charging us for consultations and time spent drafting, we would look at the hours and we would go back and say, we see you've charged us for a consultation on the 15th and you've billed it as 3 hours, but according to our notes, that consultation was 2 hours. Can you clarify? And counsel may come back and say, oh, apologies, that was an error because that meeting originally was meant to be 3 hours, which is why my secretary billed it like that, but we will reduce. So that is what you would want to see happening so that you deal with each invoice. And by the time it's loaded onto the system for payment and it's in that queue, you know that the information on there is correct and that invoice has been verified, that amount is now due and owing. Then the SCA judgment also referred to the RAF appointing an accounting firm, Sizwe Sloluba Global Grant Thornton, or SNG, in May 2023 to conduct investigations into the irregular referral of patients to Sunshine and overservicing and overbilling. That report was not given to the committee when we originally requested information. We also requested information when the interim board came before us saying if there is any information that shows that Sunshine has acted irregularly, please provide that to us. And it wasn't provided. So we then went back after the SCA judgment earlier this year to ask again for that. Similarly, that SCA judgment also referred to a complaint being lodged with the Health Professionals Council of South Africa, and that also wasn't included in the bundle that was provided to us. So we recently sought further clarity from the RAF on the status of those investigations, and they provided us with a letter from Malachi and co-attorneys, which indicated the following. In respect of Universal Care, the company was appointed by them on 2 August 2023 to review RAF claim samples due to overservicing and overbilling, especially inappropriate admissions and extended ICU or high care stays. And it was intended that the investigation would have 3 phases. Phase 1 being the assessment of 100 claims. Phase 2 being a review of 1,346 claim files. And then phase 3, a review of historical paid claims for recovery, so where monies have already been paid. And Universal Care was given 3 tranches of files, but only completed reports in respect of 29 files. And they then submitted the 11 September 2023 report, which I've taken the committee through. And they say that that report was used in the Swanepoel J matter, which I deal with a bit later. And that Universal then also did the supplementary report in April 2024 based on that judgment. So in other words, those 2 reports from Universal relate to those same 29 case files. Universal was then asked at a later point to depose to a confirmatory affidavit in the defamation claim against the RAF and Mr. Palela. I don't know if members remember this, but Mr. Palela and the RAF was sued about statements that Mr. Palela had made, which were disparaging remarks about Sunshine, and they wanted to use the Universal Care report in that matter to substantiate as to why these statements were made. And they refused, that being Universal Care, refused to depose to this affidavit. And according to Malachi, in light of the above, no further work was undertaken by Universal beyond those 2 reports that were already submitted. So the rest of the work, the investigation in terms of the balance of the files, then never happened. SNG, according to them, was appointed on 24 May 2023 to investigate the overbilling and the irregular referrals or transfers to Sunshine. And they held 4 meetings with SNG between June 2023 and February 2024. And they also provided them with documentation, and they were at the stage of arranging hospital interviews. However, the investigation, according to Malachi, remained preliminary and no formal report has been issued. They say that as of 4th of March 2025, RAF's Internal Forensic Investigation Division, the FID, took over the investigation, and SNG did not bill for any of this preliminary work. So in other words, for these consultations, because there is no report. So that letter really is not clear as to why there wasn't a report prior to the RAF taking over the matter by 4 March 2025, when they were informed. And also what the basis would have been to cancel that agreement with SNG. One would have supposed that SNG, if they were lawfully procured to do this work, would have insisted on completing that contract. So we really don't have information as to whether there's any breakdown in relationship or anything else that could have added to this, and also what would have informed RAF to suddenly take over the investigation then in March, whereas in the previous year they wanted SNG to do it. And they refer to SNG in their court papers also. Be that as it may, RAF has not been able to provide any further report from its internal forensic investigation division. So notwithstanding that they apparently took over the investigation last year in March, they've not been able to provide any other report. In terms of the complaint to the Health Professional Council, Malachi informed us that the complaint was submitted on 24 May against Sunshine, where they requested the registrar to consider appointing an inspector under Section 41A of the Health Professionals Act. And that would be for purposes of investigating alleged misconduct or contravention of the Health Professions Act. They say that they held a meeting with the HPCSA on 9 January, and they were advised in that meeting that complaints must be lodged individually for each practitioner via the online platform, and they need to identify specific issues per practitioner. They also advise lodging a complaint with a health ombud. They then go on peculiarly to say that no further correspondence has been received from the HPCSA since that meeting, and therefore there is no further status update on this complaint. The way I read it, members, is that, of course, there would be no further correspondence because the HPCSA indicated clearly what needs to be done. You need to lodge individual claims for each of the individual practitioners that you are accusing of committing irregularities. That seems not to have happened at all. So I'm not sure what exactly they're waiting for from the HPCSA, because the position ought to have been clear from the conduct of the meeting on 9 January 2024. So be that as it may, even though this matter is also then referenced in court documents to show that the RAF is actively investigating Sunshine Hospital, they've not carried through with this or the SNG or the universal care matters. And then, of course, we also know that the SIU is investigating the RAF, and that they conducted interviews with Sunshine Hospital representatives, but they've not provided the committee with any evidence of wrongdoing on the part of Sunshine Hospital. Of course, that process hasn't been concluded, and we don't have a final report in relation to that proclamation. But as things currently stand, we don't have any adverse information from the SIU. This obviously all then leads to litigation. based on this moratorium in respect of the payments, because whereas previously payments were late, they would eventually be made. In this case now, what happened was that no payments were being made. So there's obviously been a plethora of matters instituted by Sunshine against the RAF. As of September 2025, the hospital had issued 6,285 summonses against the RAF. That's increased substantially since then, and they'd obtained 647 judgments, totaling approximately 180 million. That's also increased. Obviously, these are moving targets. In the majority of these matters, judgment in favor of the RAF was obtained either by default, so they haven't come to court and the judge grants by default or the magistrate, or by agreement between the parties. Following the moratorium and RAF's refusal to pay the amounts approved on the RNYP, Sunshine then approaches the Gauteng High Court on an urgent basis in December 2020, where they seek payment of approximately 353 million, which was the total sum on the RNYP at that point in time. And they propose a minimum monthly installment of 36.9 million being the minimum amount required by the hospital for their continued treatment of patients and to avoid closure. And the RAF doesn't file any opposing papers in that matter. And eventually they elect to agree by the proposal by Sunshine, resulting in the court granting an order by agreement between the parties. So basically they are admitting that the monies are owed and that they're going to pay the monies in these tranches. They then proceed to make payment in installments as required by that court order until they cease without explanation in May 2022 with making payments. And this then in turn prompts Sunshine to obtain a writ of execution. So basically that is where you get a court order directing the sheriff to enforce the judgment, because at this point you already have a judgment that monies are due and owing. So they then get the writ of execution, being in an amount of 36.91 million, being the missed payment for the May 2022 tranche that was due. And the non-payment led thereafter to several further cases. By July 2022, there was an outstanding amount exceeding 301 million. And what we've tried to do is a summary of some of those bigger or main matters, and the matters referred to by Mr. Ford. But obviously, I must stress that there are literally thousands of smaller matters also. So I'm going to start. What I've done, just to try to make things easier for reference purposes, is to refer to a matter by the name of the judge that first heard the matter, because obviously all of the matters involve Sunshine. So I can't simply refer to it as a Sunshine matter. So the first one is the Bakwa matter. And following the issuing of the writs of execution, the sheriffs of the court served the writs on the RAF for purposes of satisfying the debts owed. And the RAF was then obviously faced with the prospect of its tools of trade being attached and sold. And they then go to court on an urgent basis to stay, in other words, to suspend those writs. And Sunshine opposes that application, and they bring a counter application seeking judgment against the RAF for the full 301 million, being the amount that was due on the RNYP at that point. The High Court granted the order. So, in other words, in favor of the RAF, and Sunshine was ordered to provide the RAF with identity numbers and documents of all the injured persons in respect of which the writs related within 10 days of the order, because they had gone to court saying, well, we can't satisfy these writs or make these payments because Sunshine hasn't given us all the information that we require. The RAF was then directed to reconcile those supplier claims and send a report to the sheriff, who must then within 5 days pay the outstanding amounts into the trust account of Sunshine Hospital's attorneys. The writs were stayed pending the finalization of that process. Alternatively, the institution of an application for rescission of the court orders or for declaratory relief. So Sunshine, RAF rather, was also saying, well, give us time so that we can go back to court to rescind some of those judgments. And Sunshine was ordered to pay the cost of that application, including that of senior counsel. However, they then approached the SCA to appeal the judgment, and they were successful. And the SCA found that the High Court's order offended the principle of finality of court orders. Really, the High Court allowed almost a relitigation of whether the claims itself were valid, which had already been done. And the court found that the correct procedure would have been for the RAF to appeal the relevant judgments, or in appropriate circumstances, apply for rescission thereof. So the RAF should have dealt with each of these as, on an individual basis. What the RAF instead sought to do through its application was to obtain an order to compel Sunshine Hospital to comply with what should have been pre-litigation procedures to determine the validity of a claim. So in other words, the court agrees that prior to you loading these invoices for payment, that is when you should have asked for all these additional pieces of information that you're now claiming that you need. The court also found that in any event, there was no evidence that the claims were fraudulent. And they set aside the order of the High Court, and they replaced it with a new order dismissing that application with costs, including the cost of 2 counsel. It bears mentioning, though, that in the SCA, Judge Smith found that there's no basis for a finding that the RAF acted maliciously in bringing the application, or that it did so for the ulterior purpose of avoiding its legal obligations. And the court then recognizes that there are these systemic problems that have haunted the RAF for years, and one can't overstate the depth of that problem posed by improper and fraudulent claims and the challenge that they present to an already overburdened RAF functionaries. The RAF sought leave to appeal in the Constitutional Court, but this was refused with costs on 16 March 2023. And following that Constitutional Court order, they then commenced again with payments to settle that debt of 301 million. So they do an initial payment, followed thereafter by installments. At this point, Sunshine has already closed its doors earlier on 1 March 2023. But because there's a resumption of payments, it allows Sunshine to temporarily reopen its doors. As members know, they've now shut permanently. Then there's the Swanepoel matter. Sunshine had managed to successfully issue 181 writs against the RAF, prompting the RAF again to approach the High Court on an urgent basis, seeking an order to suspend or stay the writs. And the RAF had argued that there were serious allegations against Sunshine and that it would be improper to enforce payment until those investigations have been completed. And the RAF further contended that the RAF Act does not permit the submission of global accounts. So these were the consolidated accounts, which was the method of billing that Sunshine had used for 17 years. So you remember Mr. Ford had said for 17 years, they never objected to this form of claim. And for the first time, it then gets raised in late 2023 in the Swanepoel matter. They argue that each supplier is expected to lodge its own claim, and that these global accounts were in breach of ethical standards by the Health Professional Council. The High Court dismisses the application with punitive costs on an attorney-client scale, and there's quite a scathing judgment here where Swanepoel J takes issue with the repeated refusal of the RAF to abide by valid orders, and instead bringing these types of allegations. And he says in the judgment that not even punitive cost orders have brought about a change of heart. And these applications have resulted in the public purse incurring substantial legal costs. He goes so far as to say it may be that courts have to start considering personal cost orders against officials at the RAF responsible for the launching of these types of applications. In this case, the Chief Executive Officer, Mr. Letswalo. He finds that the submission of global claims is not a breach of ethical rules, and that Section 17.5 of the RAF Act obliges the RAF to pay suppliers. That section does not prescribe the manner in which claims must be lodged. So, in respect of the RAF's claims that there was evidence of impropriety, the judge stated that A further complaint against Sunshine is that its claims are statistically at odds with claims by other hospitals. And the RAF says that of the 41,254 open claims on its systems, the claims by Sunshine represent 0.5% of the number of those claims, but 16% of the value. And this alleged anomaly raises the suspicions that Sunshine has inflated the claims. Whatever the reason for the alleged anomaly, the fact is that the RAF employees have been intimately involved in verifying the claims. The FID has investigated and found no evidence of wrongdoing. And furthermore, if there had been rife overbilling on an ongoing basis, as the RAF suspect, then one would have expected the RAF's verification systems to have found evidence thereof. There is no such evidence. Despite the SIU having investigated Sunshine for the last 2 years, it has evidently not found any wrongdoing. And the court then goes on to also speak about the universal healthcare investigation and what they find there. And the court criticizes them for not including the entire report, but only relying on selected passages, and that there was no confirmatory affidavit from Universal, who was responsible for preparing that report. And the court finds that the allegations don't take the matter any further. He finds that it's unconvincing that there's widespread impropriety, and says that the RAF has simply thrown mud at Sunshine in the hope that some of it sticks. More importantly, each of the claims for which the writs had been issued had been obviously previously adjudicated by a court, and court orders had been granted in some matters with the RAF's consent. And given that the RAF had known about these judgments for months, one must then ask the question why the RAF did not investigate those specific claims individually. And then, of course, to then seek rescission of judgment based on that. So the court isn't satisfied with the fact that the RAF really has these broad sort of allegations that it makes, rather than substantiating these on a case-by-case basis. The RAF did seek leave to appeal that judgment, but the application was dismissed by the SCA on a punitive scale in January of 2024. They then brought a further application for leave to appeal on petition, which was likewise dismissed with costs on 2nd of May 2024 on the grounds that there was no reasonable prospect of success. And then, aggrieved by this dismissal, they then applied to the judge president of the SCA for reconsideration of the dismissal. So that's a little bit technical, but what they wanted was for the SCA to allow them an opportunity for just the dismissal portion to be reconsidered. So in other words, by doing so, for another bench or another judge then to decide, actually, there are grounds for an appeal. That doesn't mean that if they're successful in a reconsideration, that they would be successful in the matter as a whole, rather that it would then allow the matter then to be heard on appeal. So the judge president allows for that reconsideration as to whether they should be granted leave to appeal, but even that reconsideration application is eventually dismissed with costs. And in that reconsideration application, the court considered this issue of the evidence of impropriety against Sunshine. And it says that RAF's reliance on an invocation of the investigation reports of multidisciplinary bodies do not in any way advance its case. There has to date been no report to hand by SNG, and that remains the case currently. Secondly, the HPCSA has not given any indication that the medical practitioners concerned have breached any ethical rules. That also remains the case currently. And thirdly, Universal Healthcare has filed a report to the effect that it investigated some 100 selected files and apparently found savings of some 29.28% of the billed amounts in 29 of those files. What is significant is that there's nothing that shows that the 100 files investigated form any part of the claims in respect of the 181 court orders obtained by the RAF. So the court is finding that these reports then are really not useful. And the problem is that the RAF seems to place reliance on these very broad allegations, as opposed to saying we've got 181 matters that are currently before this court, let us conduct some sort of forensic investigation on these 181 matters and present that evidence to the court. But that wasn't done. And so the court can't really place any reliance on these broad sweeping allegations that don't directly relate to the matters in front of it. Then there is another matter, the Mali matter. Earlier, I had said that in response to the Bakwa matter, Sunshine had brought a counter application in the Gauteng High Court. And the application was dismissed by Mali J with costs on the basis of res judicata, which is a legal principle which prevents the same parties from relitigating a case or claim in which there's final judgment. But they were granted leave to appeal, and the SCA this year, quite recently in March, ruled that the application by Sunshine did not constitute a reconsideration of a previous final judgment. Rather, what Sunshine was trying to do was to enforce the judgment that had already been granted in their favor, and therefore res judicata did not apply. So that was the only reason that Sunshine was actually going to court, was to deal with enforcement of a judgment that was already there. The SCA criticised the RAF for failing to comply with judgments, accusing it of having a policy of non-payments of judgment debts. So that's quite strong language for the court to accuse the RAF of actually having a policy position on how it treats judgment debts. It referred to an earlier incident where the RAF attended an auction of attached goods and purchased the assets themselves. And in respect of these buybacks, the court notes a quote from Mr. Palelo, who was the spokesperson at the time, where he said that claimants weren't affected by this. And he says, you must remember that they come and take our furniture. And today they opened a storage and took the kind of furniture that we don't use. I mean, sometimes they come and take the desks. I mean, all the time that I go to the offices in Centurion at head office, there's always a paper at the door with a list of assets that they want to take. So that's what the sheriff would have attached there. And fortunately, what they do is then auction the assets there, and we just continue to buy them back. We're going to do this until we resolve these issues. So quite a brazen statement there that notwithstanding that these goods have been purchased, they're owned by the RAF, that the RAF is willing, when the goods are auctioned by the sheriff, to simply go and buy back and spend money on the same goods that it ought to have already owned and shouldn't have lost had the judgment debts been complied with. And the court finds that the refusal to comply with court orders amount to a breach of the RAF's constitutional obligations. The RAF, like any other institution, has an obligation not to interfere with the functioning of the courts, and also to assist and protect the courts to ensure their independence, impartiality, dignity, accessibility, and effectiveness. And their failure to then comply with court orders is then seen as an infringement of that obligation. The SCA then accordingly orders the RAF to pay Sunshine an amount of approximately 92 million within 7 days of the date of order, and to provide them with the RNYP list within 7 days initially, and then thereafter every 14 days. In addition, the RAF was ordered to adjudicate all amounts submitted by Sunshine within 120 days of receipt, and then also to pay a separate 158 million that was due in terms of the May 2023 RNYP. So there are multiple claims happening at the same time. So I know it can get a little bit confusing. The committee requested and received information following this March judgment from the RAF with regard to payments made subsequent to that judgment. And on 29 April 2026, the RAF provided the committee with a spreadsheet of payments and an email in which they confirm that they've already paid 249 million towards Sunshine Hospital claims, with the next scheduled payment of 3 million taking place after the long weekend on 28 April that has just passed. And that would bring the total claims paid to 252 million. On 11th of May 2026, the attorneys for Sunshine furnished the committee with a copy of correspondence it sent to the RAF, in which they allege that the RAF has failed to adhere to the SCA court order. According to them, there's an outstanding balance of approximately 78 million in respect of that 92 million, and that the payment of the RNYP amount of the 158 million has not been paid. So it seems that the payments that are being made are older historical payments and not the payments related to this particular judgment. And the correspondence further alleges that there were several short payments. So where you have an individual matter, an invoice that perhaps has 10 items, it could be a case that only 9 of the items are paid, or some of the items are paid at a value lesser than what the amount claimed is. And the attempts that they've made to obtain clarity on that have been unsuccessful. And again, what Sunshine is now saying that in these circumstances, they may have to institute contempt proceedings because there's contempt insofar as there's non-compliance with that court order. I have spoken again to the attorney for Sunshine Hospital, and it seems that the matter persists. And obviously, the interest is accumulating daily on those unpaid amounts. The next matter is the Hutchinson matter, and that's got to do with the defamation claim that we referred to previously, where in March 2024, Mr. Palela, during an interview on ENCA, said that Sunshine was involved in a corrupt scheme, and they felt that there was over-servicing and overcharging. And according to Mr. Ford, this prompted Sunshine to then approach the High Court to seek interdictory relief and a declaration that the statement was defamatory. And the High Court found that the RAF did not produce evidence of corruption. And the only report attached to its answering affidavit, which was the September 22 report, in fact found the opposite. And Mr. Palela submitted the following in support of the contention that the statement was not defamatory. So in our law, if you make a statement that appears or sounds to be defamatory, but it's fair comment, the court won't find that you've committed an act of defamation. So you're allowed to make fair comment. Fair comment would obviously require that you have a basis on which you make that comment. So it can't simply be hearsay or something that you pull out of your thumb. But according to him, he said that the statement he made was not made recklessly and without factual foundation. They were supported by investigation reports commissioned and presented to the RAF. The very reports that the applicant seeks to rely on do not support the conclusion that is made by the applicant, in this case, obviously Sunshine, and that these reports have not exonerated the applicant. He disputes that, and he says that the allegations pertaining to the irregularities and corruption are still ongoing, including that the SIU is investigating. The judge, however, found that there was no evidence supporting the allegations and says that although there was much innuendo made in the affidavits, there's no clear and patent facts which cogently demonstrate this. Again, it's this issue of the RAF sort of using broad, sweeping defenses when they're in court, rather than dealing with particulars. Accordingly, the High Court ruled that the statement made was false and defamatory, and it interdicted Mr. Palela and the RAF from making further statements that say or imply that Sunshine is involved in a corrupt scheme. Now, finally, to observations and findings. It is clear from the evidence before the committee that Sunshine, like any other private medical service provider, did not legally require cooperation or any other form of agreement with the RAF for purposes of treating MVA victims. Sunshine was within its rights to admit such patients at its own risk and to lodge claims in terms of 17.5 of the RAF Act. It's therefore concerning that the termination of the cooperation agreement seemed to be viewed as the basis for the subsequent refusal to pay Sunshine Hospital. And it cannot be gainsaid that any patient has the right to seek and receive treatment at a healthcare facility of their choice, provided that they and the facility in question accepts the risk of same. It's further clear from the content of the cooperation agreement that the genesis was a pilot project that was mutually beneficial for both parties. It allowed the RAF full access to hospital records, medical service providers, and patients with their consent, as well as the use of office space and a vehicle. Sunshine was provided no guarantee in respect of the transfer of patients. There therefore appears to be nothing untoward about the arrangement, given that the committee has heard evidence that the RAF had a presence at other public hospitals, and in this case, the Sunshine Hospital was one of very few private hospitals who were willing to carry the risk of treating MVA patients without necessarily being in the receipt of an undertaking from the RAF to pay or an upfront payment from the patient. Given that Sunshine was willing to treat these patients, it made good business sense to ensure that RAF officials had a presence in the hospital for purposes of actively managing case files and ensuring that treatment was clinically appropriate and billed in accordance with applicable tariffs. The RAF instituted a moratorium on payments in April 2020 without providing any notice of same until August 2020. The RAF has a statutory obligation to pay service providers in accordance with Section 17.5 of the RAF Act. The decision without notice to make a blanket decision to halt payments failed to take into account this legal obligation, the impact that that would have had on patients and on the medical service providers. It's concerning that the RAF appears not to have provided Sunshine with the full particulars of instances where it was being accused of overcharging or overservicing patients to allow Sunshine Hospital and the individual medical practitioners then to respond fully to each of those allegations. This would have allowed for the filtration of valid claims versus fraudulent claims, if any, without adversely impacting on the care of all patients. So there was nothing that stopped the RAF as and when these invoices were being received to query the invoices, to even negotiate invoices if they felt that there was overcharging or overservicing. Notwithstanding that the RAF's very own FID report found no evidence of wrongdoing against Sunshine and advised that the moratorium be lifted, the RAF persisted with its refusal to pay claims. The committee acknowledges that the reports prepared by Universal Care found evidence of overcharging and overservicing in a small sample of cases, but it's concerning that these reports are based on desktop exercises, and inexplicably no opportunity was provided to Sunshine to offer an explanation. In fact, it appears as if Universal Care may have even been prevented from accessing such information, because according to them, there weren't any opportunities to request additional information or clarification. Equally concerning is the fact that these services were procured on the instruction of the RAF's attorneys amid litigation processes, giving an impression that it was a case of first making accusations and reaching findings and then scrambling for evidence. This would explain why the RAF did not have time to procure such services itself. It's also telling that Universal Care refused to depose a confirmatory affidavit in respect of the defamation matter, and their services appeared to have been terminated abruptly thereafter. It's equally concerning that notwithstanding referring to and using the S&G investigation to substantiate decisions not to pay Sunshine Hospital, that investigation did not proceed and yielded no evidence whatsoever. The referral of the investigation, as I said previously, to the FID also does not appear to have made any progress, as the committee has not been provided with any further evidence. It's therefore clear that the RAF has been unable to provide any court with substantive evidence of impropriety by Sunshine, despite having had plenty of opportunities to do so. Instead, they've repeatedly relied on vague and generalized allegations of impropriety. It ought reasonably to have been expected that the RAF would have done everything possible to uncover any impropriety, but instead it appears to satisfy itself with incomplete and unreliable information. The RAF further appears to have also failed to consider that those payments loaded onto the RNYP have already been subjected to an internal audit process. As such, that process itself ought to have been assessed to identify why any overcharging or overservicing issues were not picked up timeously. Clearly, if they persist with the argument that there is overcharging and over-servicing, then one must ask this question: why is it that when invoices are verified, that isn't picked up at that stage? And if you're not picking it up in the case of Sunshine, it then would follow that you're also not picking it up in the case of any other medical service provider. And so the RAF could then be paying amounts really that are not due and owing. Instead, the RAF turns a blind eye, which in turn leads Sunshine to obtaining hundreds of judgments. And this is a situation that persists. As recently as yesterday, there were judgments against the RAF in respect of Sunshine matters. As pointed out by the courts, those judgments were by and large default judgments or by agreement. So, given that the RAF does not have sufficient legal capacity to defend matters, it's crucial that these objections to supplier claims are made timeously during that internal audit process. And their failure to do so has resulted by September 2025 in legal costs and interest in a staggering amount of 23.79 million. In fact, I've spoken to the attorneys for Sunshine who've informed me that that interest amount now sits at over 33 million. The committee has no option but to find that such costs amount to fruitless and wasteful expenditure. So it's really quite a bizarre situation where the invoices aren't objected to, they loaded onto the RNYP, the amounts are owing, the amounts are not paid. Sunshine goes to court. The RAF doesn't appear in court to defend the matter, so Sunshine then gets default judgment, or alternatively, the RAF is there and they then agree to pay. Either way, you're still then sitting with interest, even after the default judgments or judgments by agreement, they then still don't pay, and that leads to further litigation and further interest costs. So it's really just this vicious cycle that seems to go on and on. And all the while, the public purse is bleeding. The failure of the RAF to meaningfully engage with Sunshine in respect of its suspicions and allegations has complicated matters. It may well have been that where the RAF was of the view that there was over-servicing or overcharging, these matters, as I've said, could have been negotiated and settled. Instead, they allowed claims to be continually listed on the RNYP. And according to the evidence from Mr. Ford, they had tried to engage the RAF. They were willing to give more information. The RAF had access to all of the records and so on, but yet didn't seem to meaningfully engage with them. The committee further notes its deep concern about the manner in which the RAF has ignored court judgments and in fact gone so far as to obstruct valid legal processes such as sales and execution. This demonstrates a flagrant disregard for the rule of law. It is further nothing short of audacious that the RAF would attend these sales and purchase its own goods. Given that these goods are being paid for twice, it must be regarded as fruitless and wasteful expenditure. There would have been no need for these sales and execution in the first place had the RAF done the necessary verification processes. The impact of these sales on staff can also not be ignored. As pointed out by NUMSA when they appeared before the committee, there's deep concern about the risk of attachments, and employees are severely affected in their ability to carry out their duties. Members that were here in the previous parliament may recall during the oversight visit seeing that you had staff sitting on boxes and so on because their desks and chairs had been removed. The above disregard for court judgment seems to have raised its ugly head again, with Sunshine Hospital alleging non-compliance on the part of the RAF with the SCA's 2026 order. The committee is not in a position to verify payments, but if same is the case, it means that any interest and additional legal costs incurred as a result thereof are fruitless and wasteful expenditure. As I've said, according to the attorney, that amount for interest has now gone up to over 33 million. And there's still, apart from the approximate 900 odd judgments that is already made in favor of Sunshine, they've got almost 7,000 that are still in the pipeline. So the matter really is far from over. As has been the trend in other matters articulated in this report, the RAF appears to litigate even where prospects of success are low. In cases related to Sunshine Hospital, The failure of the RAF to be adequately prepared to litigate their matters is also worrying. This failure includes instances of not providing the courts with sufficient or substantive information, attempting to adduce evidence at a later stage, and failing to file opposing papers, thus attracting the ire of the courts. So, you go and apply for a decision of a judgment, but you don't have a valid cause as to why you're applying for rescission. So typically, rescission would be where there really is a proper basis in law as to why you didn't defend your matter when the court first heard it. So, for example, you were involved in a car accident and you then couldn't come to court. That may be a basis on which to apply for rescission. The RAF, though, seemingly without having any proper legal basis on which to apply for rescission, continues to apply for rescission. And according to the attorneys for Sunshine, they've not been successful in a single one of those rescission applications. And of course, this is compounded by the fact that they don't have sufficient attorneys dealing with their work, which is why they're getting all these default judgments in the first place. And then lastly, it is the committee's understanding that approximately 13 employees of the RAF were dismissed in relation to allegations of collusion with Sunshine. It may be that there are more, but these are the ones that we're aware of. Some of these employees responded to the call for submissions and claimed that they were unfairly targeted and that their dismissals or suspensions were retaliatory in nature and based on their perceived affiliation with Sunshine. The committee does not intend to make findings on the merits of the labour matters. However, given that the FID report could not find any evidence of collusion between Sunshine and its employees, the submitters' versions, if true, mean that the RAF incurred costs without any legal basis. Such costs would include the costs of initiators and legal representatives, salaries of employees during their period of suspension, and associated legal costs to defend their actions. As I indicated, what's also worrying here is the fact that it seems that in those labour matters, and we'll deal with it at a later stage, the fact that that agreement was terminated was used as a basis for saying staff should not have had dealings with Sunshine Hospital. But of course, that didn't mean that Sunshine Hospital couldn't admit patients in the first place. But we will deal with that aspect a little bit later on, Chair. Chair, I think that brings me to the end on this portion in Sunshine Hospital. Thank you.
Thank you very much, Ms. Ibrahim. Much appreciated. So I'd like to give you some time to catch a glass of water and so on. But while you do that, I will ask the members to make their contributions at this point. I think from in my observation, a couple of things stand out. The first is that I think that if the Road Accident Fund feels that they should, there are anomalies with, financial anomalies in what Sunshine Hospital was charging them. The most important thing to do would be to identify them and link them to specific claims, because that is what they do. And it's clear that they have not done that, because even though the claims are consolidated, they always consolidated in respect of one patient or one claimant, even though there may be a group of specialists and other doctors that would have worked on that particular patient. So that is the one thing. It's clear to me that they've not done that. The second thing that for me is concerning is the fact that they've spent so much money on litigation, such that I do think that we may need to ask them how much they've spent on litigation after, all of the judgments that they've had against them in the courts. So that's the second thing. The third thing that is worrying is that if they are not able to prove at all, including through their own investigations, that employees and Sunshine colluded, what really is the basis of dismissing employees on the same allegation they have not been able to prove anywhere else, including producing reports? I know that we We are not here to review cases, but it is worrying that every time they're asked to prove the same allegation, they can't. But they have been suspending and putting employees through disciplinaries for the same thing, where in court they simply cannot sustain, and they're spending money in the process. The final thing is that it is clear when you look at the at the actions by the sheriff that until and unless the road accident funds funding problem is resolved, they are always going to struggle in that case. And I'm wondering if these kind of issues are not partly as a result of the road accident fund trying to prevent money from leaving the door, because they're going to become insolvent in the middle of a month and not be able to meet their short-term obligations, and therefore they have to keep delaying. It's claimants on the one hand, it's medical specialists on the other, it's lawyers on the other, etc., who don't get paid because they're trying to juggle. But those are some of my own observations. Honorable Beasley, let me give you a chance. Thank you.
And thank you, Chair, and greetings to everybody. I don't know if Ms. Abrahams is back, but once again, the presentation, the report is phenomenal. So really hats off and congratulations and thanks to all of those involved. So Chair, this is firstly a question to you. What's the update with the Letsolo's charging? I've got so many people coming to me and asking me what's an update. I mean, there's no doubt he's been a wrecking ball. I'm on record saying he's a sociopath, and it's in the press, and that I've made such a. But what is anything happening? I mean, just read this report. Every time we come with a report, the wrecking ball that the RAF has been on the courts, on crash victims, on employees, on service providers. And he hasn't come and he never accounted for his decisions that he's made. So is there an update, Chair? And if you're going to lay charges, I'm more than happy to accompany you, because something needs to be done. And then, and I think you raised such a good point, Chair, is that they're in so much financial crisis at the RAF that they can't pay claims even if they want to. And it's just going to get worse. It's just going to explode. It's just, So if they want to pay, they can't pay because they don't have the money. So, I mean, I don't know where the money's going to come. So it's just going to get progressively worse. It's what's the word? It's getting bigger and bigger and bigger every single day. So I'd just like to ask Ms. Abrahams, and it obviously doesn't come part of this report, but just for my own understanding, if a court order gets issued, can one just ignore it? And then what happens if it is ignored? Does a litigant have to go back to court to enforce it? What happens if, when a court order gets issued? And is there any way that we can actually get an idea of how many court orders have been issued against the RAF that haven't been settled? Because, just what happens, it just amazes me that a government organization, constitutional organization, can just not obey a court order. And then, Chair, you also mentioned the impact on employees. And I think this is something that we mustn't lose sight of. And I know we're going to come at later, but the devastating impact on employees, it's absolutely massive. Many of these employees, all of them have done no wrong. They've just been targeted because they've just been caught in the crossfire. And I think that is hugely tragic. And then, do we have an idea of how much money currently is owing to Sunshine Hospital? What is the quantum of that? And then similarly, I mean, Sunshine Hospital had the funds to take the RAF to court. How many other smaller service providers that haven't been able to and have actually been decimated? And then also we talk about this 500 billion of liabilities, but there's also the liabilities of supplier claims on the other side, service providers. And I don't know if we have an idea or we can quantify that. But generally more comments and questions, Chair. But you just read this report and the wrecking ball that the RAF has become, and it's becoming a bigger wrecking ball every day because the matter is just getting worse. Thank you, Chair.
All right, thanks, Honorable Beasley. I think it might assist us actually when we make our request for a briefing post-audit from the Auditor General, that we ask the financial statements to be simplified, because we just need to know on one slide how much is outstanding in claims to claimants, to service providers, etc., because I think that will give us an idea of the scale of the problem that the road accident fund is dealing with anyway. I had a brief conversation in the House with the Deputy Minister of Transport, and he said that they are trying, the road accident fund is trying to accelerate the claims, and I think last month was the highest number of claims they've paid in 1 month in a long time. The road accident fund, that is. So that was good news, but I think the funding issue remains live. It's a big one, and it cannot be taken lightly or just ignored, even in amongst all the problems. So all of those comments, Honorable Beasley, are well noted, and I think for our later, maybe the recommendations phase, we should get some submissions from the road accident fund in order to inform our views. Honorable Atkinson.
Thanks very much, Chair. Chair, just something that doesn't relate entirely to today's presentation, but it's something, a comment you've just made now about the funding that RAF receives. And in essence, we know that the way the RAF is set up is completely, it's basically set up for failure. I mean, there's no way that the money that is taken in from the fuel levy can actually cover the kind of claims that can come through if the act is followed in its entirety. So there's just a huge shortfall between the money that we get from the levy and the money that needs to be paid out. And in that light, I'd just like to say that I think this report that we're doing at the moment is the most comprehensive investigation into RAF that any government department has done over the last 30 years, okay? And I think at the end of the day, it's going to become the gold standard for, if anyone wants to understand RAF and understand what needs to be done, that this SCOPA report that we're doing should be the item that they should refer back to, because we've done a absolutely endless investigation, seeing so many people, getting so much evidence that I think there is very little else out there that can be known by RAF that won't be in this report. And the reason why I'm saying this is it's my concern that the Minister appears to be pushing ahead with the RABS bill, which I think you've already mentioned actually won't solve the problem, and in fact might just exacerbate it. And I do think it might be worthwhile having an off-the-record discussion with the Minister and maybe ask them to actually delay any further changes to RAF until we've actually published this report and people have had a chance to understand exactly what the problem is and what the required solution might be. But I don't think the required solution is going to be the RABS bill. And in fact, I think it might well exacerbate the problem even further. Because in essence, to run two parallel schemes, which is what the RABS bill will require, will cost between up to 70 to 80 billion a month, and we're only getting 48 billion in it as it is. So it's completely financially undoable, basically. And I don't think that the people should be living in a world of mystery, believing that the RABS bill will actually resolve the problem. It won't, and I don't think the finance minister will allow them to do it. But I think what we do need to look at is, in our recommendations, is to bring in a system which might be a hybrid system, but one that is actually financially doable for the country. And then just referring back to Ms. Ibrahim's report today, she did make a point in one of the judgments there that the judge, just by the sheer lack of concern, I think, that the RAF, and particularly Mr. Letswalo, expressed towards the amounts of money that they spent on legal fees, things that almost certainly would get thrown out of court. I mean, it goes beyond fruitless and wasteful expenditure. I mean, it's almost criminal liability that they just knew that money was getting completely wasted and they were just spending money on legal fees like a drunken sailor, basically. So in one of those judgments, the judge did refer to the possibility of a personal court order against Mr. Letswalo, a personal cost order against Mr. Letswalo. And I do think as part of the recommendation, because the sheer lack of care and the sheer arrogance, in a sense, of just allowing things to go ahead, knowing that there was very little cause of success, should result in some way of us being able to reclaim some of that money back from Mr. Letswalo and possibly the board members as well. And I know I've mentioned this before, but it just seems to be a recurrent theme, is that just absolutely no one seemed to care about legal costs. And as we all know, that ultimately comes out of everyone's pockets, out of all of us, out of all taxpayers are paying that. It's not just some unknown entity called the government and called the Treasury, but it's actually every taxpayer has been funding Mr. Letswalo's complete excess in the way that he dealt with legal cases. So that's just the point I want to make. Thank you.
Thanks very much, Honorable Atkinson. In fact, I realize, Honorable Beasley, I also never dealt with your question in respect of the issue of laying charges. We should be able to put that on the table at the next meeting, so that we can then proceed with the implementation of that resolution. So I think what we'll do is, when we discuss the next portion of the report, there will be a memo from legal that is shared with members, so that we can then proceed accordingly. So the matter is nearing finality. I think, to some of your points, Honorable Atkinson, let us look at all the different topics, and let us very carefully work out instances where we believe funds have been wasted in an egregious way. I think there are instances, although you don't want any, there are instances where an institution, management, or a board spend money in good faith, and that money tends to have been used in the wrong way, or has been used for a fruitless exercise. But there are instances where at some point it becomes clear that things are being done for their own sake, and public funds are being used extensively in pursuit of something that is obviously futile. I think in those instances, we have to debate as a committee as to what consequences should follow for the individuals concerned. So I would suggest that we take all of those together, and then we are able to say, in these instances, we recommend the following, so that there can be proper consequences. I hope that will that will serve the purpose, Honorable Atkinson. I just want to know if there are any other comments from the honorable members. I don't see any hands.
Yes, no, me, Chair.
Oh, Honorable Neil May, please go ahead.
Yes. No, thank you, Chairperson. Firstly, let me appreciate the report. The report provides a clear, concise, and comprehensive account of all matters under review. I think from our history in looking at all these issues, I think it is absolutely perfect. It is such a sad thing to see that a hospital collapsed financially and finally closed in 2023. Staff lost jobs, patients were transferred, and then not to mention all the other issues from the RAF staff, those that were disciplined. Chair, the area that I wanted to ask is that what if we looked at the lawyers that had advised RAF? I mean, should they not at some stage also be held responsible? It's the cottage industry for lawyers and RAF, if you come to think of it. All the litigation that took place when the courts were saying that there's no case, there are all these judgments against RAF. And I mean, you can have a look at it as we go along. I mean, there were 181 court orders that were ignored. And surely the legal fraternity also needs to take some responsibility. Chair, I want to concur with my colleagues that Failure to comply with court orders is not an administrative error. It is a breakdown of the rule of law requiring personal accountability. I do believe that civil recovery of losses, fruitless and wasteful expenditure should be taken from the CEO, the former CEO and the board. I mean, the personal liability in terms of the PFMA is there. And I think it is something that we need to really put in our recommendation going forward. Thank you.
All right, thank you very much, Honorable Nilmay. I think all of those are well noted. I don't know if there is any other comment, but I also thought that the team did exceptionally well with this section, because it's also, I think, one of the things we always ask about is whether suppliers get paid within the 30 days that the government promises that they would do. There should never be unnecessary litigation. It should be sort of a once in a while thing, because the government institution concerned has a justifiable case for stopping payments, so that we don't find ourselves as South Africans where we are overpaying for services rendered. One of the things I'd like us to, when we get to recommendation phase as well on these matters, because sunshine is not just about the payment issues. It's also about, and I'd ask members to note that comment in this section of the report, about the fact that there are some things that we need to highlight to the Health Portfolio Committee, because it shouldn't be a norm. It shouldn't be common that road accident victims end up in a private facility in the first instance, unless that person has medical aid. One of the things that has surfaced here is that there are many instances where the public hospital does not have the capacity to treat the victims, and therefore they end up in a private hospital, I think at a much higher expense than they otherwise would be, which contributes to the issues at the Road Accident Fund. One of the last areas, and this is for the members to just reflect on, is that we just reflect on the funding model at some point, so that we can just think about what recommendations we can make, if any. And again, I think we can invite further submissions from the Road Accident Fund. So, honorable members, somebody is not on mute. Otherwise, honorable members, if we are happy with this portion of the report, then all that's left is for me to thank Ms. Ibrahim, to thank the Secretariat team as a whole, because it's teamwork, for the work that they've done so far. It's really exceptional, and we really appreciate it. And that we shall adjourn for today, and then we convene next week. I just want to say, on an unrelated matter, so that the members are aware, that I have received yesterday a letter from the city of eThekwini. I will distribute it, asking for a deferral to another date. I am going to consider it now with the Secretariat team just now after this meeting. That became aware of that letter late yesterday. So we're going to have a discussion, and then a report, consider the representations made therein, and then report back to the members today still, so that I know what to write back to the city of eThekwini. I am not inclined to recommend that we agree, but let us look at what they are saying, they're putting forward as a justification, and then we take things from there. But you will be informed, honorable members, in the next hour or two. Okay, Thank you very much, Ms. Ibrahim. Thank you so much. And to the team, thank you so much as well. This has been great. Much appreciated.
Thank you, Chair. Good weekend, everybody.
Thank you.
Recording stopped.